So in the last few videos, we've been talking about the right to exclude, the right of the property owner to keep someone off their land or to prevent someone from possessing their personal property. And the right to exclude, though, is just one example of a right associated with ownership. So in addition to the right to exclude, there's the right to possess, a right to transfer, including the right to gift something, the right to sell something, the right to devise something in the case of a will, a right to use something, a right to modify something, a right to destroy something in certain cases. And this bundle, if you will, of rights is sometimes referred to with the metaphor of a bundle of sticks. And one thing that's important to recognize and important in understanding the nature of property rights is that one can have property ownership of a thing, even though not every one of the bundle of rights, every one of the bundle of sticks are necessarily available. For example, we might say that we own our organs, and we are allowed to gift them, insofar as we may, for example, donate a kidney, but we are limited in our rights to sell our organs. Conversely, if somebody has filed for bankruptcy, they may have a right to sell property, and that would bring income in for the estate and therefore potentially benefit the creditors, but they may not be allowed to gift their property because that would tend to lower the amount of value for the bankrupt estate and therefore be prejudicial to the interests of creditors. There's all kinds of limitations we may have on our ability to use property. An owner of a factory is subject to all sorts of government regulations on emissions or the like. And in all these examples, not having a stick in the bundle does not in any way undermine our ability to say that somebody owns the thing in question. Likewise, property rights are often relative. And what do I mean by that? I mean that there are many situations where we may say that somebody owns a thing, but multiple people have an interest in that thing. Taking my house, for example, my wife and I are title owners to our house, and yet our bank has a secured interest in the house. And if we stop making payments on our mortgage, that bank's interest can then ripen into a right to possess and then eventually gain title to our property. Or take the law of finders. If somebody loses a thing, that person retains rights to recover it against the person who finds it. But the traditional view is that the person who finds it still acquires rights against the world, except for the true owner. The point here is that multiple people can have an interest in a thing, even though we might colloquially refer to one person as having the ownership interest of a thing. So these observations form a basis for a view of property as not being about rights to a thing, the so-called in rem view, but rather about rights between people respecting a thing, what judges may call an in personam view. So picture a group of people around a factory, one of whom we agree is the owner. Now, as we've discussed, that doesn't mean that the owner's rights are absolute or that others don't have a say in the use of the factory. So, for example, one person may have loaned money to the factory owner and now has an interest in the repayment of the loan that is secured by a mortgage, and that mortgage now encumbers the title of the owner. A failure by the owner to repay the loan may result in a transfer of title to the lender, and that possibility reduces the current value of the owner's interest in the factory. Or perhaps the owner gave a lease to a tenant, and that tenant now enjoys a right of possession of part of the factory in exchange for rent. Likewise, if smoke from the factory unreasonably interferes with a neighbor's enjoyment of their land, the factory owner may face a nuisance injunction that may limit the ability to use the factory. So all this underscores the idea of property rights as being not necessarily about things, but about people, a bundle of rights defining social relations with respect to a thing. To fully understand the nature of the owner's interest in the factory, we have to understand the relational interest to other people who also have an interest in the factory. That said, some have argued that there remains a value to the view of property as being about rights to a thing. For one thing, This is probably what most law students come to law school thinking property rights are, and there's an intuitive common sense aspect to it. So recall the Jacques case. In Jacques versus Steenberg Homes, the court didn't have to engage in any kind of complicated assessment of whether Steenberg Homes should or should not have been allowed onto the Jacques' land. It was a simple trespass case. It was straightforward. Steenberg Homes did not have a right to engage in the trespass, and it didn't matter who they were. That exclusion rule would have applied to just about anybody. And this kind of impersonality of rights is usually the norm. No one can come onto owned land unless the owner allows them to do so, absent unusual circumstances or special carve-outs in the law. And that's how most of us operate in everyday life. We will often come across an item that is unattended or come across somebody's land, and we automatically assume that that property is subject to someone else's ownership, even if the owner isn't there. And we have a natural inclination, or at least most of us do, to respect those rights. There's also arguably a political dimension to all of this. Some see the bundle of sticks view that we've been discussing as a problem, claiming that it invites too much regulation by the state. The logic goes something like this. If rights are endlessly divisible and completely relative, then the state can go pretty far before a property owner has a claim that the state has taken property in a way that requires compensation under the Constitution's takings clause. One stick may be regulated, but others remain, so what have you really lost? But if, say, the right to exclude is fundamental, then a state limitation of that right is much more likely to look to a court like a taking that requires the state to pay before the regulation can take place. And a good deal of the Supreme Court's takings law jurisprudence turns on this kind of reasoning. And the flip side, of course, is that an absolute view of property, or a view that tends more towards that end of the spectrum, makes certain forms of regulation too difficult to accomplish and may make it excessively difficult for property law to balance the interests of all members of society. So which view resonates more with you may to some extent be determined by your willingness to countenance government regulation, depending, of course, on the circumstances, the regulation involved, and the nature of the property interest at stake. And it's also the case that what we may think of as descriptive issues quickly veer into normative questions, not only of what the state should or should not be allowed to do, but also what property owners should or should not be allowed to do with their rights. Thanks for listening.